My name is Stas Bodrov, and I'm here with Michael Pierce. We are both lawyers at Strigberger Brown Armstrong. It's a full-service insurance defense firm with 3 office locations in Toronto, London, and Waterloo. Throughout our presentation today, please feel free to use the question and answer box located at the bottom of your screen, and we'll address all those questions at the end of the seminar. Today, we're going to discuss a recent decision, a recent insurance coverage decision from the Ontario Court of Appeal, FCS Lanark versus Cooperators. I'm going to give you a little bit of a background about the facts, the decision from the lower court, and then Michael is going to go through the analysis from the Court of Appeal. So this case has to do with the Family and Children's Services of Lanark, FCS for short. It is a children's aid society, and one of their functions is to investigate allegations of child abuse. Around August of 2015, FCS retained the services of Lanark Communications, and Lanark was retained for the purpose of, among other things, reviewing and refreshing the FCS website to ensure that it remains functional, serves their purposes, and as well maintains compliance with the legislative requirements. In 2016, in July, a class action was initiated against FCS as well as its directors. The class action was for a sum of $75 million, and it alleged that in late 2015, a confidential statistical report was prepared for the FCS Board of Directors, which included personal information of approximately 285 clients or subjects. The report was stored on the FCS website on their servers, but it was supposed to be secure and not accessible to the general public. The class action alleged that one or more individuals hacked into the FCS servers, retrieved the report, and then published the hyperlink to that report on 2 public Facebook groups. FCS, in turn, initiated a third-party claim against Lanark, seeking general and special damages and contribution for indemnity in the main class action lawsuit. The third-party claim included allegations of negligence in providing advice and professional services, and that it breached its contractual obligations to FCS. The third-party claim alleged that the report was published on Facebook, as well as screenshots were included on videos on YouTube. Lanark was insured pursuant to 2 policies of insurance with cooperators. The first was a CGL policy, and the second was a professional liability policy. As required by the contract between FCS and Lanark, FCS was included as an additional insured on the CGL policy. As a result of the class action, FCS, being an additional insured on the policy, requested that cooperators defend and indemnify it in the class action lawsuit. Cooperators denied that request on the basis of an exclusion that was included in the CGL policy for data and any personal injury arising from the distribution or display of that data. After the third-party action was initiated, Lanark also requested that cooperators defend and indemnify them, and not surprisingly, cooperators also denied that request, citing a data exclusion in the professional liability policy. As a result of this, all 3 parties, FCS, Lanark, and cooperators, brought their own application for determination on whether cooperators had a duty to defend and indemnify FCS and Lanark pursuant to their policies of insurance. At first instance, cooperators argued that it had no duty to defend due to the coverage being excluded by the data exclusion clauses. FCS and Lanark, on the other hand, argued that the data exclusions did not exclude all claims against it. Alternatively, they argued that the exclusions had the effect of nullifying the insurance that cooperators undertook to provide. The lower court concluded that the claims brought against Lanark and FCS in the class action and the third-party suit were broad and comprehensive, and that they were not limited to the distribution of the report on the internet, and that the exclusion did not apply. The court further concluded that cooperators should be able to rely on the data exclusion for the duty to defend was an important issue that should have been determined on a full record. In essence, the court stated that an application was not the appropriate forum to determine whether the the complex issues raised by the broadly worded exclusion clauses. Despite the fact that the court found that it couldn't resolve this issue on application, it went on to state that there was still a possibility of coverage because cooperators did not discharge its onus of establishing that the substance of the claim, the class action of the third party, fall within the data exclusions that they were relying on. Finally, the court made a decision that there was a conflict of interest between cooperators since they insured both Laraday and FCS. So cooperators was required to defend each party independently, and the defense of each party should not be reporting to cooperators. Not surprisingly, the cooperators appealed that decision, and the matter was brought before the Ontario Court of Appeal. Michael?
Thanks, Stas. So as everybody probably knows, the Court of Appeal did overturn the lower court decision. Now, normally I wouldn't do this, but I want to put up the actual exclusion that was in question, because the wording of the exclusion is important, because the Court of Appeal found that this exclusion was quote unquote clear and unambiguous. And as a result of that, the Court of Appeal found that the reasonable expectations doctrine did not apply, and that also the contra pro forentum did not apply, so that the exclusion did not have to be construed against the insurer. So for those of you on the webinar who are insurers, this exclusion is an example of an exclusion that the Court of Appeal has said is quote unquote clear and unambiguous. So if your data exclusion, or if you have a data exclusion in your CGL policy, or if you're writing professional indemnity or E&O insurance, and you have a data exclusion in that policy, and it doesn't look like this, you might want to consider amending it to be more in line with what's shown here. So the Court of Appeal said that there were three issues that needed to be considered in the appeal. The first was whether or not the duty to defend could be determined on an application. And the Court of Appeal specifically found that the answer to that question was yes, and in fact was quite critical of the lower court for refusing to make a decision and and for saying that a decision would have to be made on a quote unquote full record. The Court of Appeal specifically found that there was a full record before the court in this case, that the contract between Laraday and FCS was in evidence, the insurance policies in question were in evidence, and the pleadings obviously were before the court. So the Court of Appeal said, look, you have everything you need in order to make a determination on this issue. The rule providing for applications specifically provides that parties can apply to the court for an interpretation of a contract. The insurance policy is simply a contract between FCS, Laraday, and cooperators. And the Court of Appeal also found that there were no material facts in dispute, because everyone agreed this is what the pleadings say, this is what the insurance policy says, and here's what the contract says. And so those are the facts that were necessary in order for the court to determine whether or not cooperators had a duty to defend both Laraday and FCS, and therefore all of the necessary facts were before the court. And so the Court of Appeal specifically said that the motions judge should have considered the scope of the exclusions, should have considered whether or not the nullification argument should apply, and should have considered the language of the exclusions in question. The Court of Appeal went on to find that the exclusions, both in the E&O policy and in the CGL policy, were clear and unambiguous, and were comprehensive enough to remove any possibility of coverage, and therefore were comprehensive enough to exclude a duty to defend. And that was the second issue that the Court of Appeal wanted to determine was, is there a duty to defend from cooperators to FCS and Laraday? And in determining that, the Court of Appeal said, look, the things we need to look at in order to determine whether or not there is a duty to defend are first the wording of the exclusions. The Court of Appeal looked at the wording of the exclusions, looked at the definition of data, looked at what the exclusions applied to, and said, look, these exclusions are clear and unambiguous. And again, I want to emphasize that finding that the exclusions are clear and unambiguous is key for insurers and brokers, I would argue, in interpreting this decision and applying it going forward. Because as the Court of Appeal found, when insurance policies are clear and unambiguous, there's no need to resort to reasonable expectations or contra pro forentum, and you can just interpret the contract pursuant to the regular rules of construction. And so it gets insurers out of that old problem with exclusions being construed narrowly and coverage provisions broadly. And as much as that's a kind of a key thing in insurance law, if your exclusions are clear and unambiguous, then you don't have to worry about it. You don't have to think about whether or not it's going to be construed narrowly or broadly. And so that is a key finding from the Court of Appeal in this matter. So the next issue that the Court of Appeal said needed to be considered was whether or not an image of a hyperlink was data. And both FCS and Larraday argued that an image of a hyperlink wasn't data. The Court of Appeal looked at the definition of data in the policy and said, look, this is a representation of something that enables you to get access to the information in question, i.e. the private information in the report itself. And so the Court of Appeal specifically found that that representation, that photo of the hyperlink, which was what was posted on Facebook and apparently in the screenshots on YouTube, was data. And so that is a key finding as well, because if a photograph of a hyperlink isn't data, then you have a serious problem with drafting an exclusion that would apply in a large number of cases, because of all it takes is for a hacker, instead of displaying an actual hyperlink, to display a photo of a hyperlink. Now you have a real problem, and everybody in the industry would have a problem. So that is a really helpful finding, both for insurers, for insureds, because it provides certainty, and for brokers, because they can say to their insureds or their clients, look, you can't rely on your regular CGL policy in order to provide coverage for cyber and privacy events. You need a different policy, or you need an extension or endorsement onto that policy. The other thing the next thing the court said was, look, we can't consider extrinsic evidence in determining the duty to defend. The Court of Appeal has also decided that, more specifically in a prior decision that came out earlier this year, which I have another blog out about, and if you want that, please let us know after the presentation. The court then said you had to ascertain the true nature of the allegations in the pleadings and then apply the insurance policy to those allegations. And the reason the court talked about that and the quote unquote true nature of the allegations is because the lower court, the motions judge, had found that some of the allegations in the statement of claim in both the class action and the third party action were broad enough to encompass not just electronic distribution of information, but physical distribution of the report itself. And the Court of Appeal said, first of all, in looking at the allegations in the statement of claim, that's not correct. So that the allegations in the statement of claim don't talk about physical distribution of the report, and therefore the allegations in the statement of claim arise out of the electronic distribution of the information in the report, i.e. data. And the Court of Appeal went on to find that all of this, even if there was physical distribution of the report, all of it arose from the same chain of causation, the same initial event, which was the hacking and the leaking of the report. And therefore the court said, look, these exclusions are broad enough to exclude all of this, regardless of whether or not there's an allegation of physical distribution, which there is not. And then the court said, look, the next thing we have to look at is whether the doctrine of reasonable expectations applies, because but what the court said about reasonable expectations is you only get there if the plaintiff can show that the exclusion in question is ambiguous. If the exclusion is ambiguous, then you fall back on the reasonable expectations of the parties. But the court in this case said, look, this exclusion is not ambiguous. It's clear and unambiguous on its face, and therefore the doctrine of reasonable expectations did not apply. But the court went on to find, helpfully, that because the exclusion was clear and unambiguous, that the reasonable expectations of the parties in this case should have been that these claims would be excluded. In other words, because the exclusion is clear, the reasonable expectations of the parties should be that the exclusion will apply in appropriate circumstances. Finally, the court considered the plaintiff's argument that the exclusion and the application of the exclusion to this specific scenario would, quote unquote, nullify the coverage provided by the policies. Now, in order to find that an exclusion nullifies coverage, essentially what the plaintiff is asking the court to do is to say, look, if you apply this exclusion the way the insurer says it should be applied, then we've bought nothing. You've bought a nullity. That what they're selling us doesn't do anything. And so what the Court of Appeal said was, look, these policies provide specific coverage for a variety of things, bodily injury from a variety of causes, and personal injury arising from a variety of quote unquote offenses, one of which is the invasion of privacy, but they exclude events arising from the distribution of data on an internet website. And so the court said, look, there is coverage that is provided even if we apply the exclusion, and therefore the exclusion, the application of the exclusion to this specific claim does not nullify the coverage provided by the policies. So from our perspective, this decision from the Court of Appeal is an excellent decision both for cyber insurers, cyber and privacy insurers, and for conventional insurers. And the reason we say that is twofold. First, for conventional insurers, one of the big concerns over the last 3 or 4 years has been quote unquote silent cyber coverage. So policies get issued for CGL or E&O or other kind of bread and butter coverages. And the concern from insurers has been that they will end up covering cyber and privacy losses because they don't exclude them. And insureds like FCS and Lariday will bring coverage applications where they have cyber and privacy losses, and they haven't bought a cyber policy, and they seek coverage under their conventional policy. So this decision essentially puts an end to that practice in Ontario. Now, whether or not plaintiffs will not bring further applications for coverage is a different question. They may, but certainly this decision will assist insurers in defending those applications and saying, look, we don't have to provide a defense on a CGL policy or an E&O policy that has a data exclusion where you have a cyber or privacy loss. The decision also aids cyber insurers and brokers trying to sell cyber insurance to their clients, because it says to everyone involved, look, you need a cyber policy or cyber and privacy policy to cover incidents like this, and you're not going to be able to resort to your conventional policy to find coverage for losses like this. You need a different sort of coverage, whether that's by endorsement, by purchasing a separate policy, or otherwise. But it simply provides clarity that you cannot get coverage for cyber and privacy events pursuant to a conventional insurance policy if it has an appropriate data exclusion. The other issue that we think is important in this case is the direction from the Court of Appeal to the motions judge saying, look, you should have made a decision here. You should not have essentially abdicated your responsibilities to make a decision by saying, this should be decided with a full record. The court was very pointed, I think, in its criticism of the lower court in saying that the motions judge is presumed to know the law, even if it's developing. And so the Court of Appeal was very specific in saying, look, this is why this rule exists. You ought not to be abdicating your responsibility to make a decision, and you ought not to be applying what they referred to as an asymmetrical standard and saying that the plaintiffs, FCS and Lariday, are entitled to a remedy, but that cooperators is not. Finally, the decision itself provides guidance for insurers as to what a clear and unambiguous exclusion looks like. So if you have a data or privacy or cyber exclusion in a CGL or E&O policy, and it doesn't look like the ones in the cooperators policies, and I'll tell you that the only difference between the CGL exclusion and the one in the E&O policy is that the one in the E&O policy had the preface directly or indirectly, which makes it broader, which I would suggest get added to everyone's exclusions if you're going to have one like this. But it does provide guidance as to what a clear and unambiguous data exclusion looks like for everyone. So certainly that will be helpful as we move forward. Now, questions. And I know that I probably talk really quickly, so if it takes you a while to come up with a question, please do let us know. One of the questions that we often get about decisions like this is, well, will the exclusion in my policy be interpreted in the same way by the courts as the exclusion in this case? And the answer to that, as I'm sure you know, depends on the wording of the exclusion in question and how close the wording of that exclusion is to the exclusions that were referenced in this case. So if you have a question like that and you have a wording that you'd like to send to us, we're more than happy to review it. And we'd also be more than happy to help you amend your applicable exclusions should you need to do that.
Michael, I think that you were extremely clear because we don't have any questions so far.
I hesitate to presume that. So if anyone has questions that they think about after the presentation or that come up otherwise, please don't hesitate to let us know. You can email either myself or Stas. Our email addresses are here, and they're also available on our website, sbalawyers.ca. You can also just Google either myself or Stas, and you will be directed to our website. We do have some
Michael,
additional Yes,
sorry, we
Stas.
do have a question from Simon. He asked, how long did all the cases take to get resolved?
So the initial class action was brought, as Stas said, in 2016, and it's now 2021. So you're looking at about 5 years now. I think the initial coverage application was brought in about 2018. So it's about 3 years to go from coverage application to an initial decision to an appeal and an appeal decision. So you're probably looking at 18 months each. So, but the reality is that in a case like this, where you've got a $75 million class action and you're facing defense costs for two parties in that class action, it's worth it, or it certainly was worth it, for cooperators to bring an application or at least respond to an application being brought by the other parties and say, look, we need this determined, because defending a class action is monumentally expensive. You're probably looking at $500,000 per party. So even if they spend $50,000 on the coverage application, it's eminently worth it. And it certainly avoids having further issues as you go.
We have another question of who acted for cooperators in this matter. And
we looked at this yesterday. It was a small firm in Guelph.
Yes, it's available on the decision. I think it lists the counsel who represented all parties. We have another question of how much the class action lawsuit against SCS settle for or get judged for. And
there hasn't been a judgment in that class action yet, and I'm not aware of a settlement. I don't believe it actually has been settled yet. The general rule for settlement of class actions in the privacy context, it depends on the nature of the information that's disclosed, but you're looking at somewhere between 1,000 and these days 5,000 or 10,000 per party in terms of settlement value. So if 285 people had their information disclosed, then the settlement value is somewhere between, say, 285,000 if it's $1,000 per person and up. But there have been lots of privacy class actions, not in this kind of space. Healthcare information and information like this, which is surrounds child abuse, is considered to be much more valuable than, say, credit card information. So it tends to be valued in a different way. But often what you see in cases like that is a lot of cases these days are getting settled for between $60 and $100 per party. But when there's only 285, that's really not enough to pay for the defense costs. So you're probably looking at a longer piece of litigation here, just because the plaintiff's demands will be a lot higher, I think, than the defense is willing to offer.
There's another question, and this is a very interesting one. Might an action be brought against a broker for not offering or recommending cyber coverage? And in this case, it was probably specifically excluded from the policy, right? So
yeah, I think, and I thank you, Warren, for this question, and hi. And I think the short answer is, might an action be brought? Yes. The question around that action is going to be whether or not a cyber policy was offered to either FCS or Laraday by the broker in question. A lot of times you will see cyber, and brokers will tell you this until they're blue in the face, that they offer cyber coverage to their clients all the time. And up to the last couple of years, they get turned down a lot because a cyber policy is an extra expense, and a lot of insureds don't think they're at risk. And so often you get insureds who will simply say, no, we don't need that, or no, I'm not paying extra for that. But in a scenario where it hasn't been offered, and then you have a loss like this, certainly, yes, in that scenario, you're going to get an action against a broker, and it's likely to be successful. But obviously the chances of the success of an action like that depend entirely upon the facts between the broker and the insureds, and whether or not this coverage was offered to the insured prior to the loss in question. But I guess the other important thing to note on whether or not brokers are going to get sued in cases like this, the answer to that question is much more likely to be yes after this decision. Because if you are an insurance broker and you don't offer cyber cover to your clients, and somebody says, well, this decision came out before the transaction that's involved in this scenario, and you, broker, should have known that this decision existed and that the Ontario Court of Appeal had already found that coverage in scenarios like this is not available pursuant to a CGL or an E&O policy with a data exclusion. So I think that certainly brokers would do well to pay attention to this decision specifically, and also to this kind of decision generically, because it's going to get used against them for the simple reason that the Court of Appeal has said these policies, CGL and E&O policies that have an appropriate exclusion, don't cover this kind of event. And coverage is available for this kind of event. You can buy a cyber policy now. Because of the uptick in cyber and privacy claims through the pandemic, cyber and privacy policies have gotten much more expensive, but they're still relatively cheap. When you look at the cost of an eventual loss, because even if you don't have a third-party claim that arises out of a privacy breach, you're still probably looking at anywhere between $100,000 and $250,000 in post-breach expenses. And that's not including defense costs for a third-party claim. So a breach like this can cost an organization $1 million before you break a sweat. So, a $2,500 cyber policy is a good bet for an insured, and maybe not such a good one for an insurer, but that's up to the insurers to figure that out, which is why rates are going up.
Agreed. I don't think we have any further questions for today, but again, if you do have any questions that come up or anything specific to one of your cases, please do feel free to reach out. We do have some upcoming webinars. Our next one is titled More Than a Feeling, where it's about turning information into evidence. That's going to be on June 2nd at 12:30. And then we have another webinar coming up, Dentistry 101, on June 24th, also at 12:30. So please feel free to register and attend those sessions. This presentation is going to be available through our website, which we will be posting shortly.
So it's almost 1 o'clock. We want to be respectful of your time. Thank you very much for attending today. Thank you for your questions. Those were great. And we hope to see you again soon at one of our future presentations.